What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great night so far. Happy Friday. Happy Friday. We made it. Another week down. Hope you guys have a great weekend. Got a good show for you tonight before we get the weekend, though. Let's see. What do I have tonight? I've got a McDuffie sighting in Judge Washington's courtroom. For those of you that do not know, Miss Rachel McDuffie no longer has her daily activities in Judge Washington's courtroom. I have no idea what she's doing. She still makes small appearances for cases. I'm guessing, her backlog, she's still covering the cases that she was covering. This one's a long hearing, and it's good. We have legal battles. We've got drama. We've got, even Judge Washington comes in with, a couple quips. Anyways, but I've got some news I need to share before we get to tonight's show. I know most of you, if not all, understand what my friend Judge King is going through right now. A lot. People still ask me almost every day. And I choose not to talk about it publicly. I did one time. I played the clip. I talked about it once, and I told everyone that's it. I'm not going to say it anymore because he's my friend. And because I'm passionate about it, I don't want to go off on a tangent that may, I may say something stupid that actually might get him in trouble. That is possible. So I've chosen not to talk about it too much, but we have news on this. The lady, the mother of the child on that fateful day was in court today. And she wasn't in court to testify or defend herself on her lawsuit against Judge King. This is what she was in court for. Gotta play it.
Have a seat, Chair. Say your full name.
I am Latoria Denise Till.
This is case number 240-461-7201. Please submission versus Latoria Denise Till. Appearances, please.
Good morning, Magistrate. Steve Benson for the people.
And good morning, Your Honor. Sydney Rushing, P78830, appearing on behalf of Ms. Till this morning. Ms. Till has been advised for constitutional rights, waives formal reading, stands mute, and has been not guilty plea be entered on her behalf.
Court not guilty plea on behalf of Ms. Till. Before you proceed with your recommendation, Mr. Vincent, is the complaining witness 41 years old or 71 years old?
71.
Okay, go ahead with your recommendation.
Judge, this defendant doesn't have any priors, but you're absolutely right. And the 71-year-old was allegedly her aunt, and the defendant was drunk and beating up on her. At this time, Judge, we're not going to be objecting to a personal. We're going to be highly recommending or requesting a no contact with the aunt through the pendency of this case.
No objection, personal, Judge.
$5,000 personal bond while his case is pending. No alcohol, you're not possessing handguns, firearms, other dangerous weapons. No assaultive contact with Willa Tyson. Refiled December 20th in front of Judge Jones. I stand corrected. No contact with Willa Tyson. No assaultive behavior while this case is pending.
Thank you.
All right. That's it on that. I wanted to show that I'm not going to comment very much more on it, except for, really. And I want to thank a giant shout out to Detective Rachel, who sent me that clip. That was actually from her channel, and she grabbed that for me, so I took it from her channel. Thank you so much, Rachel, for letting me know. And Jenna, I saw your comment about karma. That's not karma. That's just, I don't know her action. started assaulting her 71-year-old aunt when she was drunk? Yeah, let's go with character witnesses in this lawsuit. Let's go. If she's bringing up, you know what? I'm getting into case details. I'm not doing that. I told you guys I wouldn't do it. I know you guys want to hear it, but I'm not. So we're going to hold on. We're going to get into tonight's video. We got to move on. Because I'm so passionate about that, I'm going to end up saying something dumb that I'm going to regret. But you know, she got a personal bond. Hopefully, she doesn't start beating up grandmas on the street. You know, what is she going to teach her kid? Okay, joke's over. All right. Like I said, we've got a hearing. I haven't seen this whole thing. This is an hour and 15 minutes long. I've seen probably 40 minutes of it. I kept going in and out of it. Just, again, it's a long hearing. Rachel McDuffie's on her game. She came back to Judge Washington's court. This is a good one. That's why I'm playing it tonight. I hope you guys enjoy it. And yeah, let's go.
All right, the 14B District Court is now back in session. The court will call the matter of the State of Michigan versus Terry Brewer, 24 FB 1224.
Good morning, APA Rachel McDuffie on behalf of the people.
Good morning. This is Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Terry Brewer. Terry, can you state your name for the record, please?
Yes, Terry Brewer. Good morning.
Good morning.
I'm looking at it.
All right, we're here for a number of things this morning. One,
Well, I already knew what time it was. Hold on.
oh, hold on 1 second. 1 second.
She gets it already in mind. You know what I'm saying? I'm understanding we upset by that.
Sorry about that.
And why would I be?
It looks like it's still playing somewhere.
You know?
All right, sorry about that. All right, we're here today on the defendant's motion at this point for a 911 call and a motion for rehearing or reconsideration. Reconsideration of the 911 call and to suppress any statements made by the defendant. And then there are some other matters that are still under advisement. Let's start with the motion to suppress regarding Miranda.
All right, Your Honor. Thank you. Okay. Your Honor, the defense is before this honorable court on a motion to suppress the statement made by Mr. Brewer, and in quotes, I believe this is the statement that this is the statement that we're here for, is that in 2016, I grabbed her. And this is due to a violation of Mr. Brewer's Fifth Amendment self-incrimination clause, Sixth Amendment right to an attorney, and indirect violation of Miranda rights pursuant to Miranda v. Arizona. Your Honor, custodial interrogation for purposes of Miranda are any words or actions that the police should know are reasonably or likely elicit incriminating responses from the suspect. On the date in question here, I believe on June 8th, let me double check the exact date, June 7th. On or about June 7th, two officers knocked at the door. They knocked and announced Sheriff's Office Police. The officers were responding to a delayed domestic violence here. And when the complaining witness opened the door, one officer talked with the complaining witness, and the other officer spoke with Mr. Brewer outside of his door. Now, mind you, these officers are not just on patrol. They're not just driving around. These officers are responding to a DV. And Mr. Brewer knows that. The officers know that as well. The complaining witness knows that as well. Mr. Brewer did not have any thought to just say, I don't feel like doing this today and start walking away. Neither that or all of a sudden just ignore the officers, go back on the couch, start watching TV that day. In other words, a reasonable person in the defendant's position would not have felt free to leave that day. And that is the key question here. If Mr. Brewer would have just turned around and started walking away, he would have most likely been facing 3 counts of R&O, and potentially a big issue could have taken place that day. Mr. Brewer might not be here if he turned around and started walking away. And we've seen it take place in our society. And that's something Mr. Brewer would not want to risk doing while he's being interrogated or investigated by the police. And my thing is, it's like, what would it have been to just read him his Miranda warnings? How long would it have taken the police officers that day? Maybe like 13 seconds to read his Miranda warnings. And the argument that people will probably make, I'm assuming, is, oh, but he was not in a custodial environment. He was not ever arrested, or he was not ever placed in handcuffs. When we know from Miranda v. Arizona that it is not limited to being arrested or being handcuffed. It applies to any suspect in an interview. I'll find this quote. A defendant can be in custody if he reasonably believes he is not free to leave the place of questioning. Even if the police do not tell him he's under arrest, do not handcuff him, do not lock him in a cell, and do not threaten him. And that's from Wyburo versus Alvarado. And the fact of the matter is, Mr. Brewer is being surrounded by what started as 1 officer to eventually 3 officers, all dressed in uniform, body cams, weapons on persons, all within arm's length. I did see, in the people's response, stating that, Mr. Brewer was 54 years old at the time of the incident and well acquainted with the criminal justice procedures and law enforcement, given his law enforcement contacts, given his history. So Mr. Brewer was 54 years old at the time of this incident and well acquainted with criminal justice procedures and law enforcement contacts, given his history. Just because you own a lot of cars doesn't make you a mechanic. All right. And just because you've been.
Yeah, Mike, you're absolutely right. Anything, they can question him all day long. They just can't use it against him in court unless they read him his Miranda rights. So we haven't heard anything that they've used. Hopefully he gets to it. This is Mr. Mansour. He's a public defender. He's new to the Judge Washington court area. I don't know much about him, but he took the place of Attorney White. He's been their house counsel public defender since Attorney White left. So he's only been there for about a month. I don't know anything about his background. He seems legit from what I've seen. Just a little bit of background on him, but let's keep going.
Arrested doesn't make you no attorney. So how are we going to say if this is what that statement is getting at, that since he's been arrested so many times that he knows the law? Actually this actually shows that he doesn't know the law, if anything. And we respectfully disagree with the people's argument there. And the reason being, that's a speculative statement in our opinion. And I also mentioned in my argument, in my brief, that Mr. Brewer was smoking a cigarette during his interview. And opposing counsel went as far as to say and call it some odd, speculative unscientific legal, I don't know. And look, it's my motion. All right. This is my timely motion. And I put that in there to point out that sometimes, people smoke when they're under stress. Is it speculative? Yes, it is. And that's part of making arguments. That's what a lot of arguments are. Their opinions, their personal experiences. There's legal analysis, there's scientific analysis, I know, but I'm making my analysis. And from personal experience, I smoked cigarettes for 10 straight years. I did quit though, but I will say, when I did smoke cigarettes, did I smoke cigarettes when I was under pressure or under stress? You bet I did. And that's just why I put it there. But if we're on the fence about this being in a custodial environment, let's talk about the two-prong analysis here. Let's see if these questions the officer stated that day elicited incriminating responses. Were those questions eliciting incriminating responses? And as noted in my brief as well, I called it something along the lines of like rapid fire. Like, when I mean the officers were letting the questions go, like, I mean one after another. Like, I'll give it to the officers. They were persistent about it. Like, the questions were, did anything happen, Mr. Brewer? No. Did any assaults take place? No. Did anybody hit anybody? No. When did this happen? Do you guys fight like this often? No. Every now and again, then the officer says, every now and again though, right? No. Okay, is this the first time this popped? Like, are you gonna read the Miranda? Like, are you gonna advise him of his rights? Look at the questions that I just read, like one after another. And if that's not interrogating, like, I don't know what else could be. These are the most incriminating questions you can ask. Like, I literally can't think of more blatantly phrased questions to ask somebody. Like, did anybody hit anybody? Did any assaults take place? What happened in 2016? Was this the first time this popped off? I'll bring up, and again, I'll bring up the people's comment here about how Mr. Brewer's well acquainted with the criminal procedure. If any lawyer is in this courtroom now and can really stop and try to imagine themselves in that exact situation, you're taken outside of your home because you're a suspect of a domestic violence and interrogated by a police officer with the questions I just read. I don't know about anybody else here, but I'm not answering those questions without my lawyer present. And the fact of the matter is, it would have taken these officers less than 15 seconds maybe to read Terry his Miranda rights. It was never read, maybe strategically, maybe because they forgot, maybe because they didn't feel like it. Either way, it's a violation. The man is pulled out of his home as a suspect in a domestic violence. Started from one officer, surrounded by three. He was asked those questions that I quoted and unquoted. The statements here that we are here for today should be suppressed in violation of 5th, 6th, and Miranda v. Arizona, and all the other case law mentioned filed in the brief and motion here today. Thank you.
Thank you. Response.
All right, before McDuffie gets into it, yeah, so he's trying to say that we don't know. I didn't see, this is apparently part 2 of this case. I didn't see part 1. I don't really know anything about this except for what I've seen already. So I'm going to try to not spoil it and kind of explain. So the defense is trying to suppress certain things that the defendant said. It's a domestic violence case. He was questioned and apparently arrested based on things he said. He was never read his Miranda rights. So therefore, the defense is trying to throw everything out. So that was just him laying down his arguments, saying, hey, you can't use what he said. You can't, he was smoking because he was nervous. Like, why is that even a thing? Like, why is that in the report? So he's trying to get all of this thrown out before they read him his Miranda rights. That's what's going on right now. So I know it did kind of seem like he was reading a script. That's why I kind of gave a little intro with him. He's new to this court. I don't know his background. I don't know how long he's been an attorney. Everything I've seen from him, he's been good. He's a good attorney. If anything, I think he's nervous to go up against McDuffie. McDuffie's a legend. He knows this. And this is probably his time to shine. He's like, I don't know what to do. That's going to be my guess for why he was reading this why it seemed like he was reading the script. So let's hear from McDuffie. This is a long one, guys. Buckle in.
Your Honor, there's quite a bit to address. I'll try to take them in order as best I can. First and foremost, counsel has presented yet another new argument today. There was never any mention of Mr. Brewer's specific Fifth Amendment rights to an attorney, nor an allegation that he had invoked such a right during this incident and that he was denied that attorney. That is a different argument, one that has not been raised or addressed until just now. There was no legal authority provided to make that argument. The argument wasn't made as a whole. So to that end, that's my response to that, which was that not only was there no allegation that that specific issue occurred, but there is nowhere in the evidence that we show that Mr. Brewer ever requested an attorney and was indeed denied one. So I think that essentially addresses that as best I can, because that just didn't occur. Second, as it relates to defense's argument overall, this is a little bit out of order. Defense is quite focused on this issue, and I think this footnote attached to it about Mr. Brewer's prior experience with the criminal justice system and his age. I think defense loses sight of the fact that the reason that was mentioned at all is because that was an argument distinguishing the case that he cited on an issue. Mr. Mansour cited the case of Yarbrough, that Supreme Court matter, and the people's response to that is, number one, the Yarbrough case was actually a finding that Miranda was not violated there either. However, the holding in that case was that in that particular circumstance, that suspect, the state failed while they were evaluating whether or not there was a Miranda violation, they failed to consider that particular suspect's youth and inexperience in coming to that conclusion. And that youth and inexperience for a 17-year-old minor suspect who was interrogated for 2+ hours outside of the presence of his parents is something that should have been considered, because he had no experience with such things, purportedly, with the criminal justice system. And someone of that age was not expected to even really realize what's entirely going on and what's at stake. So the error was that it wasn't considered. However, the fact that had it been considered or not, the conclusion would have been the same, which is why there was still a finding, even under those circumstances, that there was no violation. So me mentioning the fact that that issue, the basis for that holding, the holding itself, is not an issue in this case. That is why Mr. Brewer's age and prior experience was mentioned, because that case was not, in my opinion, a good argument in terms of a Miranda finding, a violation. Next, Mr. Mansour is correct. We are talking about arguments today. And to some extent, all of us have personal experiences. But what we're here to argue today is not simply subject to our own opinions and our experiences. It's not even subject to the opinions of the law enforcement that was present at the scene. They were asked to appear. I have them here today. Deputy Vanderoos and Deputy Clark are present. Unfortunately, Deputy Piragi is on military assignment and is not able to appear today. But what the case law says about Miranda is that this is not a matter of the subjective opinions of law enforcement. These evaluations and this analysis is supposed to be an evaluation of what a reasonable person would have felt in that circumstance, which is why I mentioned at our last hearing that it's really about watching the video and making a determination of what that circumstance is and what a reasonable person would have thought. for an officer or deputy, in this case, from the sheriff's office, to provide their opinion that they don't believe he was in custody doesn't really affect the court. May certainly have some questions, and that's why they're here to answer any. But it's not their opinion of whether Mr. Brewer thought that he was in custody or not. In fact, it would. Well, I'll just leave that alone. So we're looking at that, and there are factors that go into this analysis. Those 5 factors specifically, as Mr. Mansour outlined somewhat in his motion, which are the location, duration of questioning, statements made, or his argument statements that were not made, presence of physical restraint, and release of the interview. We at the end of the questioning. In this case, generally, Mr. Brewer, there was a 911 call, as we know, which caused him to come to this location. And Mr. Brewer was asked some questions about what happened, as was the complaining witness in this matter. As I mentioned in my response on page 5, the basis for Miranda is not that the individual being questioned is supposed to or is expected to know the law. That's not what the basis is. That's not what the background is. It is also not only not a requirement, but there's not an expectation or a baseline, just sort of common sense issue that the warning must be or needs to be given at the start of every police interaction. When I quoted People v. Hill in my response, it I think states pretty plainly that police are to ask general questions on the scene to figure out what is happening, and that it's an act of responsible citizens to give whatever information they have. Once we get to the point where somebody feels like they are being forced to or compelled to or coerced to speak against their will, they're in a situation where they can't leave, that is when the Miranda analysis then comes in. It is not necessarily supposed to be a default, let's just start it off this way. As a matter of fact, the courts have held that that impedes law enforcement investigations and general safety, because it causes officers to be put on the defensive upfront, and they're not able to even get a voluntary answer to a question. Somebody has the option, obviously, to say no. The speculation as to this could have turned into something ugly, that's an entirely separate, I think, speculative scenario. Yes, if officers asked to speak with somebody, if they asked them to stop and they have some questions, somebody were to take off and start running, yes, it could be a potential attempt, R&O or attempt R&O, but that has no bearing on the Miranda analysis. Somebody feeling free to leave an environment where questions are being asked does not preclude some other offense that they could commit in the process of feeling free to do so. This is not, the example that he gave was not one of a conversation happening between Mr. Brewer and law enforcement officers and him inciting to leave. As a matter of fact, throughout this entire interaction, the goal was that Mr. Brewer did leave. What was happening this entire time, Mr. Brewer kicked it off by explaining, I'm trying to get back on the bus to Milwaukee. We were just talking before you guys got here about me. This is not going to work out. I'm getting ready to get back on the bus to Milwaukee. She was going to buy me the ticket. Arrangements were already being made for him to leave. The officer's entire focus, one, obviously they have to find out what's going on, but as soon as they did, they said, okay, well, here, we have what you told us, we have what she told us. We need you guys separated. You said you were going, so do you have a ride? The majority of this interaction was trying to figure out who could pick up Mr. Brewer, how much money he had available to get a ride with an Uber or something like that. Would the victim, the complaining witness, even be willing to pay? And she was, but she did not feel safe there, and she was willing to make arrangements for him to leave. So as far as him leaving, that was the goal the entire time. He was certainly free to go. The questioning itself did not last for the amount of time that counsel suggested. It was actually probably closer. The parameters, the window of questioning was within 30 minutes. I think it was even less than that in terms of finding out what was happening. Back to those factors. So we talked about the location of the questioning versus inside versus outside of the house. The people believe that does not weigh in favor of a custody finding. I'm not sure what that argument meant in terms of most arrests happen outside versus inside, but there's nothing about that setting or that situation that suggests, as a matter of fact, Mr. Brewer freely moved from the outside to the inside multiple times during the course of this. I also cited an example of a time where Mr. Brewer somewhat escalated that situation and pushed past. He chest bumped Deputy Vanderos to get inside the house when he was being spoken to about talking to the victim. Mr. Brewer seemed to be very free to move about in whatever way he wanted to during this interaction. He was only asked one time, to not directly address the victim. He didn't do that, and he wasn't, I don't want to say reprimanded, but there was no directives given to him even about that. The duration of the questioning I just addressed. But just to be more specific about that, counsel alleges that 47 minutes, which is really just the runtime of one of these deputies' body-worn camera videos, was unusually long. I don't know what basis he was using to say that that was unusually long or to establish what long or short may be in this context, but I provided a number of examples where the courts have looked at that exact issue, held that 30 minutes was deemed to not count towards any sort of violation versus the 2 hours in Yarborough did weigh towards more of a finding of custody. And for some of the Michigan cases we've had in between, they took a neutral stance with 90 minutes, not really being a factor or being a neutral factor. Again, we're looking at something much closer to 30 minutes here. Going down to the statements made during the interview. Counsel's motion focused on the statements not made by police with reference to the fact that they did not advise him that he was not under arrest at any time. That's actually not true. There is a point where the deputies did in fact tell Mr. Brewer that he was not under arrest, which was a bit later in the interaction. But I've already spoken to the fact that there is no sort of default that the intro to every single interaction is a reading of these rights. There's no evidence that Mr. Brewer was ever coerced into providing answers. Mr. Brewer spoke very freely at several times, going on at length about things he wasn't asked about at all, going off in detail about some things, and yes, answering some direct questions. As to the environment itself, Mr. Brewer was not standing in the middle of 3 deputies in arm's reach of him, as if that was some sort of intimidating environment for any extended amount of time. As I described, Mr. Brewer was standing outside talking to one deputy because he was being primarily separated as the interview took place with the complaining witness inside the house. At one point, Deputy Vanderos then exited to ask a question about his side of what happened. And Deputy Clark was actually standing somewhat further behind Deputy Vanderos during that time. They then returned into the home to find out what the Uber arrangements could be to get Mr. Brewer right away. So the picture that I think is created by defense is somewhat inaccurate in suggesting that these are 3 deputies breathing down Mr. Brewer's neck for 47 minutes. I just want to be clear that that is not the case at all. With physical restraints, yes, it's true. He was not handcuffed. I never argued that there was a handcuff requirement. I think it's just kind of, I don't want to say indisputable that when somebody is handcuffed, that they are in custody, because there has even been a U.S. Supreme Court finding that, or maybe it was the Michigan Supreme Court, but there has even been a finding that for someone who was actually handcuffed, that still did not constitute custodial interrogation, but we don't have to go that far for those examples. It's not even relevant here. Mr. Brewer was never under arrest. Mr. Brewer was not detained, or there was never an effort, I think, to detain him in the sense that he needs to stay put because they're investigating something and he may very well be arrested and taken from the scene. I'm just scrolling down a bit. Release at the end of questioning. The entire period of time, again, for this entire body-worn camera video has been used as this period of interrogation, which is not accurate. But Mr. Brewer, as shown in this video, as everybody's going back and forth, there are phone calls being made to people associated with him by the complaining witness. Mr. Brewer's talking to the deputies about what options he has, who he knows, how much money he has, just, what his plans are, what his abilities are. And after quite a bit of this back and forth about how can he get to the bus station, can we get an Uber, the need to go to the bank and get money first to purchase that, the deputies offer, if it'll save everybody a headache, we can just take you. Mr. Brewer's response is, oh man, that'd be great. So Mr. Brewer obviously agreed and was appreciative of this ride to the bus station by the deputies. Now, as to whether he was in custody, especially for Miranda purposes during that time, the people would argue that he was not. This was him. First of all, the questioning about this incident had long since passed. He was getting a ride that he agreed to, that he wanted to have. And obviously throughout this, the tone and the nature of this interaction, they are laughing. There are some jokes made. There is clearly no tension present whatsoever. Mr. Brewer just accepted that ride. That is a point where right before he got into the patrol car, he emptied his pockets He had a brief pat down for safety. That's probably one of the only times I think in this interaction where they asked him, put your hands behind your back. And he clearly said, you're not under arrest. I just need to pat you down for safety before you get into the car, basically. And they go on their way. So this is not a custodial interrogation period that lasts from the moment that they knocked on the door until he exited this car at the Greyhound bus station. I think far from it. Last couple of points here. I want to make sure I cover everything. I mentioned in the motion, I'm not sure why Mr. Mansour was recounting some of the statements that the victim made outside of the presence of Mr. Brewer, because that's not Miranda relevant. But since counsel chose to, I included some as well, which go back to the fact that she was not comfortable, not safe being with him. So those statements are in the motion. The court, obviously can review those. Finally, Mr. Mansour began by stating that we are here regarding his statement on his past conviction. And one of his arguments was this corpus delicti rule in terms of the fact that he shouldn't be allowed to bring that statement in about his past conviction. And I just wanted to make that clear. The intent of that is for people to not be convicted of something that didn't happen. If you think about scenarios where there are oftentimes young people too, but people who are questioned, who are interrogated in very coercive, extended sleep deprivation sorts of environments for multiple hours at a time in the attempt to get them to confess to something that they did not do. In those situations where deception is used and things like that, that's, I think, one of the things that's intended to prevent is breaking someone down to the point where not only do they not feel free to leave for Miranda purposes, but they are broken down physically, mentally, psychologically, until they end up confessing to something they actually didn't do just to be able to leave. Sometimes on a false promise that as long as you tell us you did it, you'll be okay. That is not at all the case here for many reasons, but having someone held responsible for something that they didn't do doesn't apply when they're already convicted of that crime. Mr. Brewer not only referenced another act, it's a conviction that he brought up. So there's not going to be an opportunity for him to be held responsible for something because that crime occurred, he was convicted of it, and it happened. I think there was one last thing. The standard here is not whether questions elicited an incriminating response. As I mentioned before, Mr. Brewer volunteered quite a few things but that he wasn't even asked about, or nor what the respondent chose to say in response to that questioning. It's about that overall evaluation of the environment. And as we can see in this video, there's nothing about any aspect of this interaction that really suggests, pardon me, got a little dry mouth here, that suggests that it was coercive, intimidating, that he felt like he was not free to go. Mr. Brewer showed a lot of freedom. The fact that he was smoking, I'm not really sure what that really has to do with anything, but Mr. Brewer was smoking before the deputies got there. So it's not even as if they offered him something to smoke, as if that has some sort of other meaning to it. Mr. Brewer carried on with what he was doing. At the point where Miss Thomas had a concern about a gun being possessed, I think it says a lot that the deputies, number one, looked for it, but simply asked him if he had any firearms on him. We're talking about a pretty weighty topic with firearms. They asked him, do you have any firearms? And he said, no, you can look. And they did look. They didn't even search Mr. Brewer's person, but they looked, he allowed them to look through his belongings he was packing up, and they did so. I can't imagine what type of coercive, intimidating, threatening, whatever environment there would be when there's even discussion of a firearm being had, and he's not even patted down to see if he has one. I think that everything else is pretty much addressed in the motion. So I believe that's off on the people if I've addressed everything.
All right. I know I let that play a long time. YouTube is not going to like me for that. But I wanted to get her entire argument in one piece. Now, I want to make this perfectly clear. I've been reading the comments, and we love Miss McDuffie. Now, you got to remember, just because she is ready for this hearing, she is really good at this, doesn't mean she's 100% right. Mr. Mansour still had some very solid points about the Miranda rights. They're there for a reason, and he brought them up, and she shot them down. But it doesn't mean she's right, and it doesn't mean he's wrong. You guys got to remember that. I don't want this to turn to, just because we love Miss McDuffie, that she's always right when she says. I just want to make that clear, because you guys have all. I've been reading the comments, and yes, we do love Miss McDuffie. She is awesome at her job. For Christmas travel expenses, thank you so much, Kimberly. I appreciate it. That is awesome. Thank you so much for the super chat. Thank you. And I was going to answer one more question. What is Detective Rachel's channel? Okay, she's not a YouTuber. She clipped the video and sent it to me, and I just grabbed it from her channel. So that's why I gave her the shout out. If you don't know, everyone that has a YouTube account has their own personal channel. It's already set up for you. You can go upload a video if you want. So that's what I'm saying. She doesn't actually upload videos to share, but she doesn't upload videos to share with, the masses, I guess I should say. But yeah, I told you I'd answer that at the break, and I was waiting for Miss McDuffie to finish. Carla, happy holidays. Thank you for all you bring us. Thank you. Thank you so much for the super chat. Thank you for hanging out with us, Carla. I appreciate it. Thank you. You are awesome. Okay. Oh yeah, no, she was ready. She was ready. She was very well prepared. And yeah, she was. She's awesome at what she does. Yeah, absolutely, she is. But there's still a lot more of this hearing going on. So I just wanted to make it, I just wanted to say these are both lawyers going back and forth. So, I like Mansour. That's what I'm trying to say. I think he does a good job. I think he tries hard, and he's a giant step up from Mrs. White that he took the place of. So I don't want to talk down to him, even though he's being destroyed by McDuffie. That's my point. That's the point I'm trying to make. Because I don't want, small chance he might see this video. I want to be like, hey man, you're doing a good job, and you just went against the best. Kind of sucks for you right now, but you're doing your thing. That's what I'm trying to do. That's it. All right, let's keep going.
Thank you. Anything else from anyone else on this issue?
Your Honor, just real quick, rebut briefly.
Okay.
Your Honor, Mr. Brewer did volunteer things. That's true, but not what he did not volunteer what we're trying to bring in today. He was that statement came from an interrogation, and counsel is correct. The duration of the body worn camera was, whatever it was, 47 minutes or what we stated in the brief. But the Miranda portion, what I'm trying to say is that happened in a specific time frame. What happened towards the end of the body cam footage. I'm not saying that those statements or that environment was custodial at all. I'm not refuting that. Yeah, he was gathering his belongings and he was taken off. I'm talking about that specific time frame when the police arrived at the door. He had that interview or interrogation with Mr. Brewer outside of his door. That's when the questions started taking place, and that's what we're here for. We're here for that specific statement. I just want to make that clear and put that on the record, because I'm not refuting what happened later on. That is not a custodial environment after the statements were made.
The court has had an opportunity to review the video in this case. I don't think that I have any questions for the officers whatsoever. I believe that in this particular case, it's very clear, the law is clear, that for there to be a custodial situation, there are certain an analysis that needs to be done. I believe that the prosecutor very well laid out what that analysis is. I agree with everything stated by the prosecutor with respect to this. And my ruling is based on her arguments today with respect to each of those issues. I agree with each point she made. And I find that there was not a custodial interrogation and the statement will be admitted. Next, let's deal with the reconsideration and rehearing.
And Your Honor, I know this is defense's motion, but I just wanted to point out one thing before we got started. The court rule 2.119 section F states that no response to such a motion may be filed and there's no oral argument unless the court otherwise directs. I understand the court may direct so now, but
I am directing so because I believe that the court made a decision in that particular situation based on information that was erroneous, and I need to review that issue again.
That's fine, Your Honor. I can respond orally, but I just wanted to, that's why I did not submit anything written, because we're not permitted to unless the court gives us explicit permission to do so. So I can provide a response to that as best I can today.
All right. Mr. Mansour, you may begin.
Thank you, Your Honor. And Your Honor, I just made that motion to reconsider just because I don't want to take too long and write an appeal or whatnot. But the one page or the one thing if you had an opportunity to read, is just the notice, or if that's not a notice, I don't know what it would be.
Well, I don't know that she's required to provide a notice, but regardless of that, the issue I have is that the basis that I made my ruling on was with the assumption that the individual was actually watching it at the time and was in the midst of an emergency. So my issue is with respect to the fact that this is a delayed report from an individual who's not even at the place at the time, and specifically, unless you're refuting Ms. McDuffie, what he wrote in terms of what was said, specifically is basically saying he's calling to make sure that Mr. Brewer can get prosecuted. That's the purpose of the call.
Your Honor, so the court's ruling actually wasn't erroneously based on that perception. What the court stated at the last time was that it acknowledged that the incident had previously happened, but that the call was being placed by someone who was concerned about that argument continuing ever since that time on through. And so therefore they want the police to respond to address that. So I just wanted to be clear. The court did not misunderstand the situation at all. And it wasn't.
I'm the court, and I'm telling you I did. So
okay. I'm just repeating what was stated on the record by Your Honor. So I recall, and I have that recorded myself actually. I recall, I would have loved to have responded in writing if I could have, but I needed to have that permission. The court has actually countered Mr. Mansour's argument by saying that, yes, these people have been arguing ever since then, and the argument, right, they need them to come so that the argument stops. So it was known that this incident happened the previous night. In terms of getting there and getting some assistance with that.
I think that's correct. I think you're correct about that part. But the part that is not correct, he's not there. He doesn't know that they're still arguing. So he doesn't know that there's still an ongoing situation for there to be an ongoing emergency.
That question is actually answered in the discovery for the issue that we just discussed, because in the video from the incident, Ms. Thomas discusses with the deputies how she called her son, who is this person who called the Malachi, who called 911. She called him and told him about the arguing continuing on, and that he then called for the police. So he does actually know, because he's being told directly by her that it's happening and it is still going on.
Mr. Mansour, response.
Yeah, Your Honor. We don't know. And even the caller said, I don't know. He called to make a domestic disturbance on his own house. But I am not there right now. I'm with my dad. You're not there? No, I'm at my dad's. Were you involved in this or no? No, I am at my dad's because I removed myself from this dude who is my brother's father, is a dangerous man. Like back in the past, my mom and him they got into it and he did some real crazy things. What's going on right now? What's going on tonight? I don't know. She got hit. I sensed something wrong with my mother. I felt a presence because he wasn't at my game today. How long ago did this happen? I don't know. I don't know all the details. Like, Your Honor, this is not the kid who was there. This is the other child who made the phone call. This is not an ongoing emergency. He stated in the call, I haven't been home in days. He doesn't even, do they have any weapons in the house that you know? No, I don't want to call my cousins because if I call this is not for purposes of an ongoing emergency. This is purpose for prosecution. I believe he stated here, oh, he's got cases in California and he's the reason why my mother had this is what we're going to introduce to the jury. This is not the child who saw this alleged incident that happened. This is a completely different child. I don't think, when we had our motion hearing on it, if I would have, brought that up, I don't think we would have ruled that way, but that's why I sent this motion to reconsider, Your Honor. I think you had an opportunity to review it, and I'm just going to leave it at that.
All right. I've been waiting for him to stop talking for a second. Julie, thank you so much. Super generous, super sticker. Thank you so much. That is awesome. Merry Christmas right back to you and your family. Thank you so much. That is awesome. Extremely generous. I appreciate it. All right. Yeah, sorry. I didn't want to pause it in the middle of a speech. So I was like, come on, Mr. Mansour, please just stop for 1 second. I got to give a shout out to Julie. Thank you so much, Julie.
I'm sorry, we can't make out what you're saying right now. Something's wrong with your audio.
Yeah, Heather is coming to visit the day after Christmas. So that's all I want on my Christmas list. My kids are happy and Heather's coming to visit me. So I'm good. Thank you for asking.
We're gonna put you in a waiting room, bring you back. All right. Yes, thank you.
I'm not sure what happened there. So, Your Honor, I just want to make sure something is clear. The reference to Malachi saying that he sensed something, I don't want that to be misrepresented as him having some sort of psychic moments where he thinks something might be wrong and decides to call 911 to come respond to that because of those feelings. What he's saying is that he had a feeling that something wasn't quite right, but then he actually spoke to his mother, Miss Thomas, and Miss Thomas then informed him that not only had she been hit, but the reference to this assault happened in front of the youngest child, the child in common between Mr. Brewer and Miss Thomas in front of his daycare. He witnessed it then. We see in the video, again, from another incident that he had apparently been crying, I think at the home and when he witnessed that incident. Malachi is the youngest child that had just was getting ready to graduate from kindergarten, I think. The statement on this call is that my brother is crying and hollering right now because I guess he witnessed it right now. According to the information that he has before he calls. So yes, he's communicating what he knows about the situation from what he has learned from Miss Thomas.
Where do you see that my mother is crying right now part?
No, his brother.
Okay.
Yeah. So and that's echoed
Malachi's the one that called Isaiah's the younger brother.
Exactly. Yeah. So Malachi is saying that Isaiah was crying and hollering right now. While he's making this call. And Isaiah, we also have that corroborated in the other piece of video where Miss Thomas talks about how he's got my son over here crying, having cussed out. It's been going on. It hasn't stopped. And she mentioned it twice. She mentioned when the officers come over, he's been yelling all day. He's been cussing me out. He's got my son crying. And then she recounts the incident and said that he was crying then too. So I'm saying all that to say this is not some sort of way out there speculation that I got the sense something might be happening, so I wanted to call you guys just in case. He is recounting this incident, not only that he was told about that happened before, but the situation at that home right then in that moment. And so
let me ask you about that, because on page 4 at line item 444, I guess it said, he says, this either happened today or tomorrow, sir. because I just got done talking to my mom yesterday.
The reference to the incident in front of the daycare was the prior incident that happened. But the situation that the right now situation is a continuation of this arguing and this conflict up through.
You're not answering the question though. He says he talked to his mom yesterday.
Yes. So I guess I'm not.
He didn't say he talked to her today and heard this.
No, he did. He on page 3, he said she called today. So it appears that he spoke to her more than once, because he said that she called him today and she had a basketball game today.
But when he says she called today, he's saying that he said something was wrong, and I felt a presence because he wasn't at my game today. I had a basketball game today, and she told me he hit me, and my brother is crying and hollering right now because I guess he witnessed it. That's not saying it's ongoing right now.
I think that's a typo in or I think that he probably supposed to be she being at the game, but I guess I'm sorry, go ahead, Your Honor, because I'm not quite
I
sure.
don't know the answer to that. I don't know whether it's a typo and that should be she is not at the game. But in any event, whether he or she is not at the game, this is not saying that it happened today.
So I think there's
at this moment. The issue is whether it's happening at this moment and there's an ongoing emergency.
Yes. So, Your Honor, I think there's two things, which is true throughout the case, right? From everybody's interview, I think refers to two things: the incident that happened outside of the daycare, which is the actual context, and or the assault, and then there is the ongoing arguing, which we discussed at the last hearing, that's been happening essentially as described by the witness nonstop ever since then until police arrive.
But what witness is describing that?
Ms. Thomas does in her video.
Right, but that's different. We're talking about this child's statement, whether that's coming in.
No, I understand, Your Honor, but I'm saying these are the two incidents. Basically, the emergency begins with this assault, and it continues on because she's seeking assistance with getting him out of the home because she doesn't feel safe, because this argument has persisted until when that happened, up until the police arrive at the home. So these are the two things that are at stake. These are the two things that she told Malachi about. She told him about what happened outside of the daycare. And
well, where are you getting that from, that it's still ongoing, that she told him that?
So I'm getting it from her interview and his call combined.
We're in the call, because we're in the call. Does he say that?
Does he say that the arguing has been going on?
It's still ongoing.
I don't know that he articulated exactly in those words that.
Right, he articulates that he doesn't know. That's what he articulates.
What line are you with the I don't know line, Your Honor?
How long ago did this happen? I don't know. I don't know all the details.
So, Your Honor, I think that's the issue. I think that's the confusion, I guess, is that that's a reference to what happened outside the daycare. When it says, I don't know when it happened, of course not. He wasn't there. He wasn't at the daycare. He doesn't know exactly when. That's why he said, I'm not sure what he said, today or tomorrow. I think that's an error too. But that incident that happened at a location and a time and place, that specific incident, no, he wouldn't know. That's the start of it. The fact that it's still a problem that she's calling him, that's not a when did this happen, because it's not a one moment in time.
Okay.
That's exactly, yeah.
Assuming you're correct, and I'm not saying I'm agreeing with that, please inform me or show me where he says this is ongoing right now.
I don't have this entire call transcribed. I can't obviously go by counsel's what's the selections that he's pasted in here. I don't believe that Malachi ever said in those words, and not the same way obviously that Ms. Thomas did, that this has been nonstop. It's been going on since then. It hasn't stopped. I don't think that he articulated it necessarily.
I don't even care whether it's nonstop. What I care about is whether he knows it's ongoing at this moment and why he's calling the police at this time. That's more what I care about. I don't understand where in here he still knows it's ongoing. I think he's calling, as he rightly should be, because he's concerned about his mom. She got hit yesterday. She still sounds like something's wrong right now at this moment. It doesn't mean that it's an ongoing
Where-
issue. It means that he's concerned about her well-being.
Miss-
overall.
And the point where I guess I would have to say, Your Honor, the point where he says, my brother is crying and hollering right now. Yes, his brother probably witnessed what happened on this other occasion, but he specifically does say right now. I don't know if that means that he, when he spoke to his mother, that he could hear him crying in the background, but he did specifically say right now. So, and again, that is corroborated by Ms. Thomas's statements as well. So the right now has to mean right now.
All right. Anything further from you, Ms. McDuffie?
Your Honor, so thank you for addressing the notice issue. We don't need to. I think that's been covered. But I guess I would ask. I would have preferred to have responded to this in writing, provided a more clear, outline of the issue. But I obviously could not because the rule prevented me from doing so. If the court is prepared to rule on this right now, I'll understand. If the court would accept some additional support for my argument in writing, I'm happy to do that as well.
Thank you. Mr. Mansour, anything else from you, sir?
No, Your Honor. Thank you.
Well, I don't think that this proves that there's an ongoing incident at that moment. And the court has reconsidered its ruling with respect to the call from Malachi. Based on that, I'm not allowing that statement from Malachi. The statements from the defendant are not custodial. The statements from Malachi are not during what he knows to be an ongoing situation. It is more designed based on everything, the totality of what I see here, not just one piece of it, but the totality of what I see here, to seek a prosecution and try to get Mr. Brewer away from his mother. So that is not allowed. What else is outstanding, please, counselors?
I
Your Honor.
believe. Oh, go ahead, Mr.
Go ahead. It's your motion. Go ahead.
Okay, Your Honor, I believe it was, from what I remember, is the Miss Thomas, the complaining witness's statement. We were trying to figure out whether
Help me or
yeah.
I still need to look at that issue. Because
And Your Honor, if for clarification for me, if this now is not, as ruled, a ongoing emergency, is that now in
it's non-testimonial and not allowed.
right?
You're asking?
I'm asking, like, is that now considered when determining whether or when you rule on the declare or the complaining witness's statement? Help me, or thank you. Is this because it's ruled a non-ongoing emergency? Is that playing into is that a factor into your ruling going into the statement that you're gonna review now?
As to what?
All right, I'm going to go off on a small tangent real quick. Mary and everybody else in chat. Heather and I just had a little debate, a discussion, a cross, if you may, about eggnog. I am 40 years old, and every time I've ever had eggnog or heard people talk about eggnog, there's been rum in it. She tells me that no, eggnog has no alcohol in it, and if you put rum in it, it's called a rumnog. It's no longer eggnog. I said I politely disagree. Eggnog has rum in it. If you want it without alcohol, it's virgin eggnog or non-alcoholic eggnog. That is what I said. What I need to hear your guys' opinion on this. Am I wrong or is she wrong? Or is she right and I'm wrong? Or am I wrong? And yeah. Anyways. That's a
like,
question. Oops.
the com-
Oops, sorry. I just wanted to ask that question. It's the holiday times. Eggnog is a thing right now. But yeah. But yeah, that's how I know. That's how I know the drink. I'm not a huge eggnog fan, so I could be wrong on this. I really could. All right, let's keep going.
Complaining Miss Thomas says comes in or doesn't come in.
Yeah, if that makes sense.
Those are separate.
Okay.
But the problem is I need to figure out what she said. So if you want to make any arguments about that piece, and I want to go back and try to find that again. I wasn't focused on that part.
Okay, you're right. Just briefly, if I may, from my experience from watching it however many times, I think this makes a huge difference. Help me compared to thank you is a big change in words. So
Yes.
yeah. So I am standing on, she did say thank you. I watched her mouth, the way it moved. She said thank you twice, but obviously I'll let you review it and make your decision respectfully.
And Your Honor, yes, thank you, Your Honor. One, since we do have the deputies here, I don't.
I buy it in the dairy aisle and then I add my own liquor to it. That's how I thought you did it. But I see your point. I
don't know if there's a question about that. I can. There's a few things. Number one, as to whether or not Ms. Thomas actually mouthed the words "help me" at any point, Deputy Vanderrose can testify to whether he, believes that was any sort of error versus something he did observe, and at what point. If the court wants to ask him about that, then I can go on to explain why.
I think we should address that issue with them present. So,
okay.
But I'm not going to be asking. It's going to be one of you. So
sure. I'm happy to do that. But I also wanted to lay out, Your Honor, a couple things. It actually does not really make a significant difference. I understand it seems like it might on the surface because help me is a sort of dramatic sounding statement and thank you sounds a little bit more subdued. But I think the reality of the situation is Ms. Thomas knows that she did not call the police herself. And she knows that she called her son, who then called the police on her behalf. Ms. Thomas did not feel safe in that environment. If police show up and you did not call them, the fact that she had to mouth any words at all, Mr. Brewer standing right behind her, the fact that she says, thank you, even if she says thank you, why does she feel like she couldn't even say those words out loud, right? She made it very clear that she doesn't feel safe in that environment. She also stated that she did not want him to go to jail, but she just he could not be in that house. So she's not seeking to prosecute him. She's looking out for her own safety. So it is not immediately clear. Deputy Vanderrose is the one who authored the report. There is a moment on the video that the court will see. The door is opened and Miss Thomas's mouth is actually not visible during the first couple of seconds. We do see her say, we see her say thank you twice afterwards. And then there's a point when they actually get into the house, Miss Thomas almost looks like her eyes well up a little bit and she collects herself. And I cannot make out exactly what, I do see the word help in what she said, but I can't make out the complete sentence. But Your Honor, regardless of the exact phrasing here, it's very clear that she is relieved that those deputies showed up.
I agree with that. I agree with
that. And she makes it very clear to them that she does not feel safe with them. She says it's been yelling, she talks about the assault the night before, and ever since then, basically continuously, with their small child, crying, she says that. And she says it has not stopped and she doesn't feel safe and she needs him to go. So in terms of the emergency, it's not about these ongoing emergencies having to be some sort of very gory, violent, situation where somebody's literally running for their life. It's the fact that they need some sort of assistance from law enforcement and that their purpose for saying what they say and for speaking with them is to get help with that situation. I think that's exactly what we see here. So when she says, thank you in her statements describing what happened and the fact that she needs him out, and that mention of the gun, for example, she says while she's there, she says, check that room. He said, he told me he had a gun. I don't know if he actually does or if that was just a threat, but it would be in there if he has one.
Right.
These are all things that kind of contribute to her, not in the environment that she's in and she doesn't feel safe. So I think that what she said to law enforcement, her purpose is she actually articulates a non-prosecution based purpose for the thing she says. When she says, I don't want him to go to jail, that is his father, but I do not feel safe. This has not stopped. Thank you for being here. I think that speaks to this being exactly the sort of ongoing emergency, which is the purpose for someone's statements. And then I can turn to Deputy Vanderoos and ask him what he recounted in his report and what he witnessed.
Well,
Deputy
here's the
Oh, I'm sorry.
reality. Now that you make those arguments, I agree with the prosecution. I don't know what she said. And in fact, regardless of what Dr. Vanderoos says, Deputy Vanderoos says, he wants to be a doctor. He's happy with that. What he says, the jury is the one that's going to make the determination of what she said and didn't say. It's not for me to make that determination. My only issue is whether or not it comes in. And I agree with the prosecution that it was an ongoing situation. Whether I don't believe that it was to the knowledge of Isaiah when he called, he didn't know, but she knows that it's ongoing. And so the statements that she's making will be allowed. And you can argue to the jury, Mr. Mansour, that that's not what she said, that she said something different, but I think that's an argument for the jury, and the jury determines whether she said thank you or help me or whichever one it was that she said. So that's my ruling. It's going to come in. And thank you for the clarity on that, Ms. McDuffie. I think that's accurate. Oh yeah, it was Malachi. Sorry, not Isaiah, Malachi. Who called? All right. Is there anything else that's outstanding?
To my knowledge, no, Ms. McDuffie.
I don't think so. I am happy to, I know that, thank you, Mr. Mansour, you revised the previous order that just focused on a 911 call. I'm happy to submit an order for what we did today. If you like, if you prefer to do it, that's fine too. Whatever works.
That's fine. If you are gracious enough to do that, that'd be appreciated, but your call.
Okay. So now, we're going to be on the jury selection for January 3rd. Is that correct?
Let's see here. I believe so. Could the court, I know it's a little bit early, and I think there's construction and everything. These are the dates that are going to be over at the service center, correct?
No, the January 3rd is, the selection is still here in the building. They will continue to be here in the building. The trials will be at the service center.
Okay, I see. Thank you. I believe so.
Can the officers leave? They probably have things.
Oh, I'm sorry. Thank you so much, Deputy Clark and Deputy Vanderoos, for being here today. You are excused.
Thank you.
Your Honor, I'm sorry, before we get into the scheduling, just to clarify from my own notes, the statements that we just ruled on, how far are we going with that? Is it just that statement when she opened the door?
Real quick, did anybody just catch that? Rachel McDuffie just excused the witnesses. Is the reason why she's not in Judge Washington's court? Did she run for judge and we didn't realize it? That was very judgeship of her. Maybe that's what she's doing. Maybe she's on that track. She didn't run for election of a judge. We would have known that. But yeah, I've never seen a prosecutor excuse witnesses before. I don't know. I felt good about it. It seemed right. McDuffie, run for judge.
Or like what are we working with here?
As far as I'm concerned, her statements come in that day.
Which ones?
All of them.
All of them. See, okay. I thought we were just.
Is there a particular piece that you're saying? I mean, well, I think at the last hearing you mentioned some parts that didn't come in. Am I
Yeah, I had mentioned, Your Honor, I said I might be willing to stipulate to excluding the statement about the gun if that was a reference to like an other act that was kind of vague.
Yes.
But it looks like, looking closer at it, we can still discuss that, Mr. Manser. It's not actually an other act, because when I look closer, she's just saying that she was told, and a statement like that is actually not, she's not referring to an incident that happened. But we can still discuss that, Mr. Mansour. That doesn't necessarily need to come in. We can talk about that. We may be able to stipulate.
And that one, the gun thing might be more prejudicial than probative, just so that you guys are thinking about that. I don't know that the gun piece needs to come in. I don't think that is, it wasn't a part of what she alleged happened in any way, shape, or form. And the jury may, in my opinion, and well, I'm just going to say this, the jury, I think, will look at that as more prejudicial to his right to a fair trial than probative. I don't think it adds to what happened that day. So that can't come in.
Yeah, I wasn't, the gun thing, I wasn't really too concerned about. I'm more concerned. I was thinking we were just talking about what we were talking about at the last hearing with the help me or thank you. I didn't think you were ruling on the entire statements that are made by Miss Thomas that day from the whole interview. She's basically saying he grabbed me the other night.
Those come in under a completely separate statute. And I was pretty sure we talked about that under your motion.
Yeah, they can't. They can't really excuse them. They have to ask the court's permission to do it. Because the witness is available to the defense and the prosecutor, even if it's the prosecutor's witness. If the defense calls a witness, they can't excuse them. They can say, I want them to stay here for further questioning, or no, I'm not going to have any further questions, and then the court excuses them. But that's generally how it goes. Just answering that.
For 7, what did you say? Motion to exclude? Where is that at?
Yeah, I'm trying to pull up that motion right now and just look through it just real quick, because that's.
We discussed it all, Your Honor. Both of our motions, the motion in limine and my response, we refer to this confrontation.
Ketchup is what horseradish is. Horseradish is 90% ketchup. It's just ketchup without the tang, or the spice. I don't agree with it, but it's people that use mayonnaise instead of ranch. Ranch is 90% mayonnaise. So it's actually, ranch is more than 90% mayonnaise, but still, it's kind of the same deal.
Sort of argument, and we made these arguments, I think, in our initial filing. So it's not. I don't think this is a new thing. I think the only thing that again would have been potentially kept out was that gun reference, but everything else, I think we argued about her statements coming in.
No, I was under the impression it was just because from what I got was help me, thank you, not her entire statement.
Yeah, you guys do realize that cocktail sauce is ketchup and horseradish, right? That's what cocktail sauce is. That's what I'm saying. Cocktail sauce is literally ketchup and horseradish. Some people make it fancy. When I make it, I do a little lemon juice and a little Worcestershire sauce. But yeah, it's just ketchup and horseradish. So that's the difference. And you put it's like a cup of ketchup to like a teaspoon or a tablespoon of horseradish. So yeah, I'm not wrong.
Made to the police officers, and if she doesn't show up, we're just going to take that at face value. We're going to show the jury that introduce to the jury that, oh yeah, he grabbed me the night before.
That's how 768.27B works.
If it's an ongoing emergency.
No, that's different. That's different. Ongoing emergency. Maybe that's not the statute, but this is the statements when it's a domestic situation.
It's both, Your Honor. It's really both. It's the fact that that the officers can testify to that effect, and the fact that the court has just ruled that an ongoing emergency was happening when she made those statements. It's both things together, and it's
All right, I apparently misspoke. I meant to say cocktail sauce, not horseradish. Now I understand why everyone's calling me out. I apologize. Cocktail sauce is ketchup and horseradish. That's what I meant to say. I apologize.
counsel's motion in limine to exclude whatever evidence that he wanted to move to exclude from trial. All of this is just the basic discovery. So I guess I'm not Mr. Mans. This is nothing here is a surprise, especially not at this point. This is our second hearing. Mr. Mansour's motion was the opportunity to say none of this should come in, and Mr. Mansour's original motion
Yeah,
has
the-
what he wanted to keep out. It's not just limited to thank you.
It says right here, although no, in the notice of intent that was filed on November 14th, it says, although no formal written notice is required pursuant to the domestic violence hearsay exception in MCL 768.27, the statements of declarant Leslie Thomas in instance case reference and all associate media, and that she outlined she intends to get all of those statements in.
and where is this, Your Honor? I'm sorry. Which one is
The
this?
notice of intent to admit statements under MCL 768.27C and 768.27B, and we argued this at the last hearing.
Okay. Well, Your Honor, I was under the impression it was just those statements, and I still, if you would still hear me out on this, it cannot. And I made this argument at the last hearing, and I was under the impression just now that you were going to take this under advisement and review the video yourself. I
have already reviewed the video. I've already reviewed the videos. She sent them to me. The reality is that the only issue for me was whether it's helped me or thank you. And I don't, as I think it through again, I don't make that determination as to what was said. That's a factual determination for the jury to determine.
Okay. But you ruled just now, if I'm correct, you ruled that this is an ongoing emergency, this whole situation?
I ruled that, yes, I ruled that when the officers get there to talk to her, she is basically, based on what I view in that particular video, under duress at the time that he gets there, they get there, and it's an ongoing emergency for her. Correct. I ruled that.
Then, Your Honor, I was okay. If you could just hear me out on this, please. It cannot be an ongoing emergency when A, she did not make the call, and B,
that's not true. That's not true. So you're telling me that somebody who is being held down and threatened, who can't make the call, when you get there, it's no ongoing emergency because they didn't make the call?
When you put it like that, you're exactly right. No, but when you guys are just free roaming the house for a whole day, this situation happened yesterday. She's calling her sons. She's calling this. She's calling that, but she's not calling the police. And then the police show up, and now all of a sudden it's an ongoing emergency. We're over here. We're here. It's just a normal day in the house. And now it's an ongoing emergency.
When did it become a normal day?
Mr. Brewer's there. The child is there. The wife is there.
That doesn't make it normal because everybody's in a house, Mr. Mansour.
Okay. I mean, I don't know. She admitted that this did not happen that day. It happened. When did it happen? Yesterday. A completely different day. A completely different calendar day. Ongoing emergency for that long.
Does she acknowledge or does she not acknowledge that they're still fighting?
Fighting could be arguing. Fighting could be.
Are they still arguing? Is she still in fear?
Let's ask her.
You'll get to do that. You can subpoena her and make her come here too.
I mean, I don't know. Her whole statements is, and if she doesn't show up, like, wow.
Okay. That is my ruling, Mr. Mansour.
We respect it, Your Honor.
Is there anything else today?
So yes, sir, I think that we're looking at that date. I know it's a little bit early. The court may not have the potential January dates yet. But if I just want to make sure that I can plan on who is going to be available from my side with any sorts of leaves and things like that. So when the court has an opportunity, I think we can, we've already submitted instructions and I believe everything. I will check and see if any of them need to be changed based on any of these hearings, but I think that we've submitted all that stuff.
I don't think we did.
Let me see.
Well, we did, it was in that last case, and that doesn't carry over to this case.
Let me see if I redid. That's true. I may be thinking about the last batch. Let's see here.
And Ms. McDuffie, I will say this. Although you're not required to provide the defense with notice of these statements and evidence you try to get in.
All right, I got to make a comment, guys. I got to make a comment. And for everyone that's watching this later, they're not going to appreciate this because I'm talking to the chat right now. I love the fact that I can annoy Jedi really easily. I can just say something. And people will start talking about it and she'll get annoyed. Just like this. Watch this. Watch this. Who agrees that butter is better on grilled cheese than mayo? Discuss. Let's go.
And you won't be in this courtroom, so I don't know if it matters as much, but it shouldn't be a fishing expedition. They shouldn't be having to try to figure out what you're trying to get in, so that now they're all over the place trying to figure out every piece of evidence and what works and what comes in and what doesn't come in. I think you should at least provide the defense with notice of what you're trying to get in that may be objectionable, and you kind of know that. So with the notice you gave in here, it does say you're trying to get in her statements. But like the 911 call, if you're trying to get in Malachi's 911 call, you know they're going to object to that because arguably it is not an ongoing emergency. So I think those are the things you have to provide the defense with notice for, so that they can be fully prepared to argue against it or make their briefs so they can argue against it. And then we don't have all this confusion about what's coming in and what's not coming in. And
go ahead, I'm sorry.
Many prosecutors don't try, and I'm just going to say this out loud, to proceed with the type of evidence that you try to proceed with. If witnesses don't show, they just dismiss the case. You're an exception to that rule. If you're going to be that exception, try to make it as fair as possible so that the defense knows what you're trying to get in and what you're not trying to get in.
Absolutely, Your Honor. I do want to make one thing really clear for the record. We haven't had any confusion in the past. And what's happening here is not that I haven't provided sufficient notice. What I've always been very open to with counsel, including Mr. Mansour on another matter, is that when there is a potential for these sorts of confrontation Crawford arguments, that I am essentially, in any case, all the discovery is on the table. But if there is something that I know, first, I'm going to notify them I intend to try to proceed right with or without this victim so that they know the arguments that are relevant. But the second thing is that I'm going to specify if there's something I know that I'm going to not try to get in, I'm going to let them know so that they don't waste time making arguments about something that I wasn't trying to press anyway. Otherwise, everything is pretty much on the table. So what's happened here, everything from this case, in my view, the gun comment, being one exception to that, but everything in this case was pretty much on the table. And we talked, I understand he wasn't here. The same thing happened with Ms. White, where we had talked about these sorts of arguments. I said, in this case, I think it's everything based on the circumstances. Other cases, I've specifically said, and Mr. Mansour was present for that, just so you know, I would only be trying to get in this, not this, right? Not this video, not this interview. You don't even have to worry about that. I'm not trying it so that you don't waste time filing a motion. We're just talking about regular discovery. That issue of no notice being required is a completely separate thing when there is issues outside of discovery. That's what I'm referring to when I say no notice is required, which is that if there is something outside of discovery that you don't even know about because it's not part of this case. And I were to try to bring that in, that it's not a formal written notice that's required, but I have to supply you with all the basis of where that will be coming from. So when I say no notice is required, it's not that I'm not communicating with them. It's that I'm not filing something that says, some formal document that says, I hereby declare I'm trying to get this in. It's just disclosing the underlying basis. If I were going to try to get something in from a previous case, for example, Mr. Brewer's unrelated domestic violence case with another victim, I would certainly be very clear with counsel, just so you know, yes, no notice is required, but I am trying to bring this whole other incident into this case. But that hasn't happened here. Here, it's just a matter of the basic discovery. So if defense wants to file a motion in limine to keep something out on the basic discovery that's there, Mr. Mansour has done this on another case. He not only, they refuted the Crawford confrontation arguments, but they referred to some evidence that wasn't even part of that. They referred to some other video with the defendant, and they said, we want to keep this out too. So my point is, Mr. Mansour knows very well how to argue that something in his discovery should not come into trial without me pointing out, I plan to get this specific thing in. So I'm never hiding the ball. I am never trying to prevent something from coming in. And for this being our second hearing, my point stands as well. If there is ever, I don't know what Mr. Mansour doesn't know or doesn't understand unless he tells me. So if you file a motion with the court and say, I'm confused about what the prosecution is trying to do, that's a waste of everybody's time. Just ask me, just reach out and say, hey, just so I'm clear. And I'm happy to say, but I don't know that there is a question. I did not know that he was confused about anything until I read his motion that he filed with the court, where he asked Your Honor what I was thinking instead of asking me. So I'm never trying to not be clear on those things.
So the other thing to say is this. In this particular case, Mr. Brewer is going to be in custody for 10 months on another matter. And you don't have a witness in this case, but yet you still want to proceed. And that part, for efficiency of the court, I'm not clear on that. But you're the prosecutor. I can't make you not do what you do. But I can tell you this, I'm not going to be making a whole bunch of accommodations for you or your witnesses in January. So you're either going to have your witnesses available or they're not available.
And I'm not asking for any accommodation, Your Honor, but I wanted to make sure that if there's something that I can avoid that's obvious, that I do so that I can give as much notice as possible to everyone about what dates the court might be looking at when the court is able to provide those. But I have not yet asked for any extensions or accommodation, and I don't plan to.
Okay, thank you. Anything else from anybody else?
All right. That's just about it. It was a longer one tonight. It was good to see Rachel McDuffie back. It really was. Sorry for saying horseradish instead of cocktail sauce. My apologies. I hope you guys enjoyed it. Real quick, Wendy, I hope my mods answered that question for you. There's a couple different ways. There's the join button right next to the subscribe button. And then at the bottom of the chat, you may see a $sign. And if you click that, it'll say become a member, something like that. Hopefully that helps. But yeah, I tried to give away my free gifted memberships to hopefully you got one, but you didn't. And I apologize for that. I was hoping you got one so you didn't have to buy a membership. But maybe you got one. I see, let's see. Sparkle Boots donated 5. I can't see who got them. Hopefully you got one. Sparkle Boots, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Saffron, welcome. Thank you so much for becoming a member. Derval, good video, but this is for the awesome chat tonight. Tonight's chat has been awesome. I'm going to hear about it in the comment section. Comments are going to blow me up because I was talking about things with the chat. It had nothing to do with the video, and for whatever reason, commenters do not like that too much. But Derval, thank you so much for the super chat. I appreciate it. Sparkle Boost for the gifted memberships. Saffron for the new member. You guys are awesome. All right. It's over. Hold on. Let's do a Q&A. Can you explain the join button is not on my screen? It happened. I've heard. Are you on a Mac or an Apple by chance? I've heard that it's set up differently on Macs and Apples. So If you're on one of those, I cannot help you. I will tell you that if you what was the tip I heard that worked? It was instead of going through the live stream, open another. You know what? I don't even remember what it was. It was something about opening a different browser. If you have Chrome, it'll be there. I don't remember what it was, but on all my devices, it's there for every stream I watch, and I use Windows and Google. So yeah, but I have heard issues with Apple with where it comes to that. No idea though. Otto, thank you so much. No, you're awesome. You're awesome, Otto. You're awesome. Thank you so much for the super chat. I appreciate it. Mary Smith for the 10 months. Thank you so much, Mary. I'm just sitting here reading the chat. I need to go. Venmo check. I love Venmo checks. Jedi! 2 a.m. Sith does not hate me, Jedi. 2 a.m. Sith loves me because I love 2 a.m. Sith. Jedi, you don't like the grilled cheese argument, so you're just okay. But 2 a.m. Sith is fucking amazing. Pardon my French. Pardon my harsh letters. Pardon my harsh letters. Jedi, that was very generous of you. Thank you so much. All right. Somebody told me a workaround once, but I don't have Apple. I don't have a Mac. I don't remember what it was, but I know that they opened a browser window. It had something to do with opening a separate browser window outside of the YouTube app. You actually have to go through Safari instead of the YouTube app, and it works there. So if you're on your iPad on the YouTube app, I feel like Apple, for whatever reason, takes that button away. But if you open up Safari and go through the YouTube link, I think it was something close to that. Don't quote me on that. But it was something close to that. All right. Let's go raid somebody. As much as I love Lone Wolf, we raid him every single night, but he's always the one that's around. He's always around. And I still haven't thought of a new joke to tell him. What do we got? Yeah, it's just Lone Wolf. It is just Lone Wolf. Hold on, let me refresh. Maybe I didn't hit refresh. What do we got? Yeah, it's just Lone Wolf. So we're going to head over to Lone Wolf, which we love Lone Wolf. I just like sharing the love, I like sharing the love. Lone Wolf is one of my best friends, so I love being able to raid him every night. But I don't want him to start relying on my raids, Like I want to share the love, and if I raid him every night, he's gonna get a big head. We can't allow that. He cannot have a big head. He can't. Yeah. For all of you that don't know, Lone Wolf and I are good friends. His channel is like 10 times the size of mine, so. That's why I joke about him all the time. Let's go hang out with Lone Wolf. You guys are awesome. Super chats, gifted memberships, membership milestones. As always, you guys are awesome. Giant shout out to Rachel McDuffie, who made an appearance in Judge Washington's courtroom. She is my second favorite prosecutor, only second to the lovely Debbie Davis, of course. But she is awesome. So when I saw her today, I'm like, nope, she's my live stream tonight. Hands down. I don't even care if it was the worst case ever. We're playing it tonight. We're playing it. Thank you guys so much for hanging out with me. Jedi, super generous. Venmo, thank you so much. I do appreciate that. Let's go hang out with Lone Wolf. Jump over there, say hi, tell him I sent you. Tell him he smells. I don't care. To go over there and wreck his ego. No, don't do that. Don't do that. Do not do that. He's still struggling from last week. So don't go over there and wreck his ego. Go over there, be nice, be polite, and say something nice. You guys are awesome. I will see you guys not tomorrow. Tomorrow's date night. I will see you Sunday. Yeah, I had to think about when the Bengals game was. It is not Sunday night. All right, you guys are awesome. Bye.
Your Honor, I'm sorry. Your Honor, if I could just somehow get a small breakout room with Mr. Brewer and just to talk to him about the future.
Of course.
Thank you. Everyone
Yeah.
have a good weekend.
Thank you. You too.
Thank you. Take care.